My name's Eric Young. I'm a partner at McKeldrew Young, a law firm based in Philadelphia that specializes in the representation of whistleblowers. The Thune-Nelson Motor Vehicle Safety Whistleblower Act was introduced just before Thanksgiving in 2014. The act was introduced as a result of a series of significant product safety recalls in the automotive industry, starting with Toyota and the sticky accelerator case, followed by the GM recall in 2014 involving faulty ignition switches, and most recently Takata airbags, which have caused serious injuries and in some cases death as a result of problems with the product that apparently, according to the allegations, were known to the manufacturer years before it became public. In each of those cases, it turns out, according to the allegations, that the manufacturers were well aware of the product defects and the reasons for the product defects long before taking any kind of responsibility and long before putting consumers on notice that these products, in some cases, according to the allegations, not only would cause the products to be defective, but could cause serious injury or death. The bill that is pending provides for whistleblower rewards up to 30% of the amount that the government recovers against these auto manufacturers in the event of a successful case. I believe that these incentives would be appropriate, and I'm hopeful that this bill does get passed into law at some point. The reality is that our government has in fact apprehended several automobile manufacturers and product manufacturers in terms of fines and penalties in the billions of dollars. And in these cases, consumers have been put at risk. People have been hurt, people have been in some cases killed according to the allegations. And so to the extent that the automobile industry has the resources to, number one, correct the problems, and number two, incentivize insiders, people that work in the industry who are aware of these problems before consumers, have an incentive to step forward and alert government regulatory authorities so that these problems can be corrected and we can avoid having our consumers put in harm's way. I believe that this Congress is considered to be very conservative and pro-business, and so there's a concern that maybe certain lobbyists might persuade Congress to not pass this bill because they'll position it as being anti-business. That being said, some of the staunchest supporters of our whistleblower laws are part of the conservative movement. For example, Senator Chuck Grassley is widely considered to be the dean of the whistleblower bar. He's been incredibly supportive of the False Claims Act. He is one of the originators of the IRS whistleblower law and the SEC whistleblower law. And so my hope is that this will transcend politics and that it's considered to be a consumer-friendly law and not anti-business, but pro-business in the sense that at the end of the day, if there are individuals in industry who, for their own selfish reasons, decide not to do the right thing, that there's mechanisms in place like what will hopefully be the Thune-Nelson law to encourage people with information about those types of misconduct to come forward and put an end to it. I do believe that the Thune-Nelson bill, as it is drafted, certainly is a positive development, and as I said, I'm hopeful that it gets passed into law. That being said, I do believe that some of the provisions in the bill could be improved upon. I don't believe that whistleblowers should be limited to those that are employed in the industry. My understanding of the bill as it is drafted currently is that it does restrict whistleblowers to that category of people. If you look at other whistleblower laws, namely the False Claims Act, the SEC whistleblower law, or the IRS whistleblower law, you're not limited in that way. The Thune-Nelson bill would be vastly improved if it included a provision that outlaws retaliation against whistleblowers who do take the initiative under the law to report fraud or misconduct. As it's drafted, the bill does not include any such language. I believe that the law could work, but it certainly puts whistleblowers at more risk than I believe is fair under the circumstances. And if you look at some of our other whistleblower laws, namely the False Claims Act, there is a specific provision in the law that outlaws retaliation for acting as a whistleblower. And that has been very effective in my experience at protecting whistleblowers, whether they're present employees or former employees. Many such individuals do remain actively employed in the industries that these issues occur, and so having that statutory protection goes a long way in my experience to protecting those individuals. The Thune-Nelson bill includes a discretionary reward provision. I'd like to see Congress, as they craft this bill, particularly when it goes to the House, include a mandatory reward provision, which eliminates the issue from the standpoint of potential whistleblowers for whether they'll be entitled to a reward or not. While we can't say for sure how it will work in the automotive industry, I can say from my experience that other discretionary rewards that have been paid in whistleblower cases are problematic because there are issues of relevance and value that are factored in some cases to pay whistleblowers less than they should otherwise be paid, in my opinion. For example, the IRS whistleblower law prior to 2006, when the new law went into effect, there was in fact a whistleblower program, but it was completely discretionary. My firm had been involved in IRS whistleblower cases even during the time period when rewards were discretionary, and I can in fact point to several cases where rewards were paid but not commensurate with the value added by the whistleblower in our judgment based upon the cases that we presented to the IRS. If you're a whistleblower or a potential whistleblower or somebody you know falls into that category, you can reach me at www.mckeldrewyoung.com or 1-800-590-4116.